Hello. Welcome to Mentoring with the Masters. My name is Jennifer Kuyrkendall. I am the Third Circuit representative for the Young Lawyers Division Board of Governors. Today I have the pleasure of speaking with Jerry Curington. Jerry is the former General Counsel for the Department of Transportation. He's also been litigating for over 38 years. Jerry, welcome.
Thank you very much. I'm pleased to be a part of this innovative program sponsored by the Young Lawyers Division.
Thank you so much for being here. Let's talk about breach of contract with the state of Florida. Under this hypothetical, a friend has a contract with the state, and the state has materially breached the contract. Can my friend sue the state despite the state's doctrine of sovereign immunity?
The short answer to that is yes. But at the risk of being a little professorial, I am going to quote the Federalist Papers number 81 by Alexander Hamilton, and I quote him, "Contracts between a sovereign and individuals are only binding on the conscience of the sovereign, and have no pretension to a compulsive force. They confer no right of action independent of the sovereign will." Again, as we all learned in law school, sovereign immunity is the doctrine that the government cannot be sued without its consent. In Florida, the doctrine of sovereign immunity, though, as applied to contracts, changed when the Florida Supreme Court ruled that the state can be sued under contract in the landmark case of Pan Am Tobacco Corporation versus State Department of Corrections at 471 Southern 2nd, 4 Florida, 1984.
Jerry, is there anything else, special procedures or other things that I should consider or be aware of when suing the state for breach of contract?
There are a few, but unlike the tort litigation under 768-28, there are not nearly as many procedural hoops to jump through. The Division of Risk Management is not involved because if you get a breach of contract judgment, you collect the money directly from the state agency. But keep in mind that the waiver is not unlimited. Pan Am authorizes suits in contract, and I quote again, "suits on express written contracts into which the state agency has statutory authority to enter." The court subsequently clarified that in the Miorelli decision, which is County of Brevard versus Miorelli Engineering at 703 Southern 2nd, 1049, Florida Supreme Court, 1997. It said, for example, that a contractor with the state who had change orders on a construction contract but were not written could not get a judgment for those change orders. So the lesson from this is, from Pan Am and Miorelli, is that make sure your client has written contracts when dealing with the state, and making sure that any amendments, change orders, or whatever form they appear in, are in writing and properly executed as amendments to the contract. Also be aware that there is one substantive procedure under Section 216.311 of the Florida statute that provides the state can only be subject to litigation for contracts that are within the appropriation of the agency. So if you're contracting with the agency, make sure they have money in their budget for the contract amount. That is very critical. Contracts that exceed the appropriation are also considered null and void. Again, like 768-28, be aware that some equitable doctrines from the common law do not apply. And in this situation, for example, you cannot expand the waiver of sovereign immunity under contract law using a quantum merit theory. That clearly would simply gut the state's immunity under contract. So generally speaking, quantum merit is not available against the state.
One more hypothetical, Jerry. A client has a personal judgment against a state employee which liability did not arise from the employee's state job. The client wants to know if he can garnish the state wages of the state employee debtor. Can he do that?
Yes, absolutely. Chapter 77 addressed that, and that's been the law for 20 years. Back in 1993, you could not garnish the state, but you can today. But if I might add one other thing I do want to talk about in terms of contracts, also be aware that the confidentiality agreements are generally, again, not enforceable. Okay, if you start to settle a contract dispute, understand that you can't make secret settlements. And also that contract provisions that attempt to have the state indemnify for the negligence of a third party or the breach of a third party can only be done if there's express legislative authority for the state agency to indemnify. That is very important.
Jerry, thank you so much for joining us and providing all that very useful information. Thank you.
Thank you. It's my pleasure.